Hello and welcome to the first episode of the Polity UPSC PT special. Let's start with our first topic, that is vehicle scraping policy. Now, what the government of India is doing right now in order to achieve its nationally determined contributions under the Paris Agreement, these are the right steps in the direction. So let's talk about it. Vehicle scraping policy was announced in the Lok Sabha, which is also known as voluntary vehicle fleet modernization program. So whatever fleet that is being introduced right now is environmentally sustainable, much better engines than the last decades before that, even before that, of the vehicles that we have right now. So these are voluntary vehicle fleet modernization program. The fleet which is already there, that has to be modernized voluntarily in nature. Implementation date is from 1st of April 2022. And the nodal agency, which agency is overseeing this? Ministry of Road Transport and Highways. A tricky question could be formulated: Ministry of Environment, Forest and Climate Change, Ministry of Finance, Ministry of Commerce and Industry. Okay. Then fitness test of commercial and private vehicles which are older than commercial vehicles 15 years, private vehicles 20 years. Remember that this could be interchanged, but for commercial we have just 15 years of fitness test, and which are older than 15 years of course, and for private 20 years is the threshold. Remember this. Okay. Moving on, we have to reduce under this policy the old and defective vehicles because they are emitting a lot. Their engine is not as healthy as the new ones are. Bringing down the vehicular air pollutants, specifically in metro cities we are seeing this a lot, and improving road and vehicular safety. Emission test, braking, safety equipment will all be tested. Unfit vehicles will be scraped, and there will be a setting up of registered vehicle scraping facility across India. There will be a discount of 5%, something to be remembered, against the scraping certificate. If the person scrapes its old vehicle, if it doesn't pass the fitness test, then a discount of 5% will be given against the scraping certificate when the person will purchase a new vehicle. So this is a kind of incentive and encouragement to scrape off the old vehicle. Okay, moving on, registration fee waiver will be also given on new vehicle, and state government will offer a road tax rebate of up to 25% and 15% for private and commercial vehicles respectively. For private it is 25%, for commercial it's 15%, and the waiver will be given by the state government. Remember what are the incentives, because that could be a straight question for prelims. Okay, and increased re-registration fees will be there for vehicles 15 years or older. This is discouragement. If I have a commercial vehicle and I go and say, okay, my vehicle has passed the fitness test, now I want to register it again, renew its registration, the government will try to discourage me from doing so by putting extra charge. Okay, mandatory fitness testing for heavy commercial vehicles from 2023. Remember the timeline. Okay, 2023, and for other vehicles from 2024. So earlier for commercial vehicles, later date 2024 for private vehicles. Okay, moving on, let's talk about right to be forgotten. Okay, petition in Delhi High Court has been filed for seeking right to be forgotten. What is it? It's a right to have publicly available personal information. My information is publicly available. If I do not want anybody to have an access of that, I want my right to be forgotten, which comes of course under the right to life and liberty, that is Article 21. Remember that, Article 21. If my information is in the public domain and I am losing my sleep over it, somebody gets an information about where I live, what is my phone number, what have I done in the past, that will breach the Article 21, right to life and liberty. Okay, available personal information removed from the internet once it is no longer necessary or relevant. There is also one catch here. What if my information is important for the judiciary to access? If it is no longer required or relevant, then only it will be removed. RTBF, right to be forgotten, discussed in Google Spain case by the Court of Justice of the European Union. RTBF, that is right to be forgotten, has been recognized under the name of statutory right to the EU. Preliminary question: consider the following statements with respect to right to be forgotten. It is recognized as a statutory right in the EU. Right to be forgotten forms a part of Article 21 of the Constitution. Both are correct. Okay. Moving on. Central Data Protection Regulation, which has been passed by the European Union. Now, European Union has this very strong law by the name of General Data Protection Regulation that has empowered the citizens to take charge of their personal information against the data collector agencies like we have Facebook, Instagram. Okay. The right to be forgotten in India. The concept is evolving in India and it comes under the right to privacy, that is center, and then right to privacy, that means, of course, the Justice Puttaswamy case of 2017. So then only the right to privacy was put under Article 21 and then RTBF is under Article 21. Hence, no specific law has been made in India and the bill, the Personal Data Protection Bill, mentions right to be forgotten. Very important question for prelims. Okay. Remember that this Personal Data Protection Bill has the mention of right to be forgotten. Very important. Moving on. Talking about this, it falls under the purview of an individual's right to privacy. It has been declared. This is all discussed. Okay. I'm not discussing it again. Moving on. Let's talk about a previous year question. I hope you will answer it correctly because the answer is already given. Right to privacy is protected as an intrinsic part of right to life and personal liberty. Which of the following in the Constitution of India correctly and appropriately imply the above statement? Article 14 and the provisions under Article 42 amendment to the Constitution, Article 17 and DPSP in Part 4, Article 21 and freedoms guaranteed in Part 3, which is of course the correct answer. We have discussed it. Let's talk about Article 355, that is popularly known as the President's Rule. Okay, what is it? Post-poll violence in Birbhum district in West Bengal is related to this particular point. Political leaders have urged the President to impose Article 355 of the Constitution, and this is because of there is a breakdown of constitutional machinery. When the Constitution is no more working properly in a state, it's called the breaking down of constitutional machinery, which forms a premise for the President's rule. And Article 355 says that it is the duty of the Union to protect states against first external aggression when there is a time of war, then internal disturbance and breakdown of constitutional machinery. Internal disturbance was very open to interpretation. Then it was replaced by the word armed rebellion. Okay. Then breakdown of constitutional machinery is also part. What is the duty of the center? Now center can take the charge over a state in case the government can't be carried on or in accordance with the Constitution. This is stated in Article 356. Whenever a state is not working according to the Constitution, it's not possible. Under Article 356, President's Rule can be formed. And this is known as President's Rule. It is known as state emergency or constitutional emergency. So, President's Rule, the term is not mentioned in the Constitution. The state emergency is mentioned. And grounds are Article 356 and 365. Okay. So, if states fail to comply with any direction from center. First was Article 356 here was saying that the state is not carrying on its duties according to the Constitution. Article 356, after that Article 365 is saying that the state is not abiding by the directions of the center, then also President's Rule or state emergency can be imposed. It must be approved by both the houses of the Parliament. The time period is 2 months. It becomes a very tricky question if you have not revised it properly. Now I can ask you which of the following statements are correct with respect to state emergency according to the Constitution. It must be approved by both the houses of the Parliament within 1 month. No, it's 2 months. And for how long it continues? It continues for 6 months and it can be extended for a maximum period of 3 years. Remember that. For national emergency, there is no limitation. For the, of course, it must be approved after a specified period of time, but there is no threshold, upper threshold till when it can exist. But for state emergency, we have the threshold of 3 years approved by the Parliament every 6 months. Moving on. This power of the President is not beyond judicial review. Very tricky, not beyond judicial review. If you have read Lakshmikant Polity, you will be able to answer this. Powers of the president, let's look at them. Take up the functions of the state government and the powers of the governor. Both are taken up by the president. Then, state legislature can be suspended or even dissolved. Declare that the powers of the state legislature are to be exercised by the parliament. So, these are the particular 3 important powers that are taken up by the president. Then, if the president, let's look at the previous year question. If the president of India exercises his power as provided under Article 356 of the Constitution in respect of a particular state, then the assembly of the state is automatically dissolved? No. The powers of the legislature of that state shall be exercisable or by or under the authority of the parliament. This is definitely correct. Okay. Moving on to the next question. Which of the following are not necessarily the consequences of proclamation of president's rule in a state? Dissolution of state legislative assembly. This is of course not done, because the powers although are taken, it's not like that the state assembly will be dissolved. That can't happen. And removal of the council of ministers of the state. Then dissolution of local bodies. Local bodies are not mentioned, like dissolution of local bodies will be done. This is also not correct. So only the second one will be correct. So first and third is correct answer here, because we had to choose the not necessarily true statements. Procedure to arrest a cabinet minister in India. Very important for us to understand. Now, a union cabinet minister has been arrested in a criminal case. Parliament was not in the session, and the cabinet minister, they enjoy parliamentary privilege against arrest in civil cases, not criminal cases, only in civil cases. Okay, such privilege is available only when the parliament is in session, or the person who has to be arrested during the session, they can't do so 40 days before the session begins, 40 days after the session has ended. Okay, remember that. The privilege is mentioned under Article 105 of the Constitution for criminal and preventive detention case. This article does not hold water. Okay, remember that as well. Member of Parliament can be arrested in a criminal case whether or not the Parliament is in session. So remember that as well. Criminal cases can be go on with even if Parliament is in the session. Okay, a cabinet minister can be arrested in criminal cases. Okay, the law enforcement agency has to intimate whom? No, it could be asked the president, the prime minister, the ministry of law. No, the chairman or the speaker of the house. For Lok Sabha speaker, for Rajya Sabha, the chairperson, that is the vice president. He or she has to be informed. No arrest can be made within the precincts of the house without the prior permission of the chairman or speaker. No legal process, civil or criminal, can be served within the precincts of the house without the permission of the boss there, that is the chairman or the speaker. Let's look at our previous year question. Consider the following statements. No criminal proceedings shall be instituted against the governor of a state in any court during his term of office. The emoluments, okay, this is 1 and this is 2, remember that. Numbering has to be done here. The emoluments and allowances of the governor of a state shall not be diminished during his term of office. So here both are correct, 1 and 2. So C is the correct answer. New regulation for adoption, let's know about this. Adoption Regulation 2021 bill has been notified. And what does it amend? Amended rules and notifications have to be remembered. This could be asked in your prelims straightforward. The adoption regulation of 2017 has been amended. So it regulates the inter-country adoption of Indian children. Okay, not intra, within, but outside. Inter-country adoption of Indian children. Amendment is in accordance with what? With which act? Juvenile Justice Act of 2015. Children whose parents move overseas with the child within 2 years of adoption will be safeguarded. Okay, so threshold has to be remembered. If the parent of the child has moved overseas within 2 years of adoption, they will be safeguarded. And Indian diplomatic missions abroad, they will be put in charge of certain their safety. This condition Indian diplomatic missions will take care of. So far, their role is limited to Indian kids adopted by NRIs, overseas citizens of India or foreign partners. Okay, now it has been extended to others. Amendment has been made by whom? CARA, Central Adoption Resources Authority, remember that. So, if we talk about CARA, it's a statutory body. Question could be asked, it's an executive body. It's a constitutional body, but it is a statutory body. But it comes under the Ministry of Women and Child Development. CARA comes under the ministry, under which of the following institutes? Ministry of Home Affairs, Ministry of Defense. If you do not know the full form of CARA for that, okay, it's with respect to adoption. So Ministry of Women and Child Development is the correct answer. Nodal body for adoption of Indian children. Which of the following is the nodal body for adoption of children? CARA. Okay. It regulates in-country and inter-country adoptions. Both are included. It has ratified Hague Convention in 2003. Hague Convention 1993 is an international convention dealing with country adoption. So Hague Convention 1993 deals with which of the following? Then options will be given. International Convention dealing with inter-country adoption, remember that. Then let's look at a previous year question. Consider the following pairs: international agreement and subject. Alma Mater Declaration, Healthcare of the People, Hague Convention, Biological and Chemical Weapons. Talanoa Dialogue, Global Climate Change. Under 2 Coalition, Child Rights. So if you know that 2 is not the correct answer, okay, so you can eliminate the option 2 here. Is with respect to adoption of children, okay, so this will be removed. That means we have to eliminate these 2 options. If we know at least 1 to be correct, Talanoa Dialogue is declaration is very famous. So global climate change. 3, any option which has 3 has to be selected over here. So this is elimination as well. Okay, like this you can deal with the questions. Moving on to the next topic, that is contempt of court. Contempt of court is very important. It has been in the news a lot of times, last year as well. So the Supreme Court held that its power to punish for contempt is a constitutional power. Who has said this? Supreme Court itself has said this. And it cannot be abridged or taken away even by legislative enactment, because it will temper with the basic structure of the Constitution. And the Supreme Court has the powers to punish for the contempt of court itself under which articles? So Article 129 and Article 142 Clause 2 deals with which of the following? You can say first could be sedition, second could be with respect to contempt of court, third with respect to advising the president, fourth privileges. So the correct answer would be 2, option 2, that means contempt of court. Now power under Article 142 Clause 2 is subject to law made by the Parliament. Remember that. The Supreme Court may pass order necessary for doing complete justice. This is according to Article 142 Clause 1. The expression contempt of court has not been defined by the Constitution. So it's a tricky thing. Contempt of court, no definition has been given in the Constitution. Remember that. High courts can also punish contempt for contempt of court under what article? Article 215. So for high courts, Article 215 is important for contempt of court. It could be asked only if Supreme Court can be the only apex court in the country to punish for contempt of court. But high courts can also do it. So that would be wrong. The power is regulated by the Contempt of Courts Act 1971. The act defines both civil and criminal contempt. So civil contempt, what is that? When there is a willful disobedience, voluntary disobedience, I do not want to abide by the directions of the court to any judgment of the court. I am doing a civil crime or civil contempt against the Supreme Court. And criminal is when any person scandalizes the authority of the court or interfere with administration of justice. To initiate a criminal contempt case, the consent of whom is required? Attorney General, so that frivolous petitions are not lodged. For this reason only, to save the court's time, Attorney General has been involved. Okay. Previous year question says, with reference to the Constitution of India, prohibitions or limitations or provisions contained in ordinary laws cannot act as prohibitions or limitations on the constitutional powers under Article 142. It could mean which of the following? Now, interestingly, we have also discussed this in our in-use series. The Supreme Court of India is not constrained in the exercise of its powers by laws made by the Parliament. That means if it has to do justice, it is not constricted by the laws of the Parliament. Okay, moving on. Let's talk about Constitution Order Amendment Bill, that is with respect to scheduled tribes. The constitutional list of scheduled tribes relating to Arunachal Pradesh has been amended. The Constitution Orders Act 2021 made It amends the Constitution Order of 1950. Who specifies the scheduled tribes in various states and union territories? Governor, Prime Minister? No, President does it. Okay, and this is under Article what? 342. So here we have to remember who does it and under what article? President under Article 342. Okay, moving on, let's talk about the following changes. In original list, Abhor as a scheduled tribe were there, and for the current list, they have been deleted from the list. Khampati, they have been changed to Tai Khampati. Mishmi, Idu, Tarao, Mishmi Kaman, Idu and Tarao, Momba, Monpa, Memba, Sartang and Sajulang, they have been included. Any Naga tribe? Nokte, Tangsa, Tutsa and Vancho. So, these are the changes you have to remember. The notified ST list can be amended by whom? The President has no say here. Amendment can be done only by the Parliament. Article 366, Clause 25 of the Constitution refers to the scheduled tribes. So, which article here we are talking about? Article 366, Clause 25. Every article you do not have to reminisce or remember, but you have to remember those articles which have been in the news, and this has been in the news. That is why we have to remember that. The list of scheduled tribes in state, union territory specific, Aka, Apatani, Dafla, Galong, Khowa, Mishmi, Singpo are important. Scheduled tribes in Arunachal Pradesh, and nearly 64.2% of the population of Arunachal Pradesh is scheduled tribe. That means this region needs the most attention with respect to development of scheduled tribes. Moving on, let's talk about Constitution 105th Amendment Act of 2021, that is the OBC reservation issue. So 105th Constitution Amendment Act is related to which of the following? OBCs. Remember this line. Restores the powers of states to identify social, education and backward classes. So the power now has been given to the states. If they have to list certain people belonging to any caste as OBC under the amendment 105th Amendment Act of 2021, separate OBC lists are drawn up by the center and each state concerned. Preliminary question could be made like, the center and the states have the same list with respect to OBCs. Not correct. Separate. Which articles are related? Articles are always important for polity. Article 15 clause 4, 15 clause 5, 16 clause 4 confers power on a state to identify social, educationally backward classes and educationally backward classes. The Act amends the provision made by the 102nd Amendment Constitutional Amendment Act, which mandated that the state government will consult the NCBC on social and educationally backward classes matters, not mandate. The state government had to consult the constitutional body related to the OBCs in any OBC matters according to 102nd Amendment Act. It empowered the President, not the Governor, not the Chief Minister, not the Prime Minister, but the President to notify socially and educationally backward classes for any state or union territory for all purposes. States and union territories exempted from consulting NCBC for preparation of their list of SEBC. Amends Article 342A Clause 1 and Clause 2 and introduces 342A Clause 3. The list of socially and educationally backward classes by states is out of the ambit of President and will be notified by the State Assembly. This is a tricky question. It's out of the ambit of the President itself. Very tricky question could be formulated, remember that. Amends the Article 366(26)(c) that defines SEBCs. Essential Defense Services Act of 2021, let's know about it. This has been passed, this particular bill, and it has become an act. It replaced the ordinance that came into force the concerned year, and there will be a ban on strike in the essential services related to defense sector because defense is an important union list subject. If the defense people, if the people who are employed with the defense industries, if they are going to, strike, then what will happen? The integrity and security of the nation will come into question. That is why employees working in ordnance factories will be under the purview of these rules. Remember that. Prohibition on strike will be there in public interest, security of the state, protection of sovereignty and unity of India, and to maintain public order, decency on morality. It will remain in force for 6 months, the prohibition order. It can be extended for another 6 months. So, remember these two. in operation for 6 months can be extended for another 6 months. Imprisonment of 1 year or rupees 10,000 fine or both for violation through illegal strike or lockout or layoff. Okay, these are the punitive measures. These are the punitive measures. First is 1 year imprisonment, 10,000 fine, or both can be done, and violation through illegal strikes, lockouts, or layoff. Okay, the service of any unit attached to the armies may be considered as an essential defense service. Any unit which is attached to the armies are a part of essential defense services, very open in nature. There will be changes in the Industrial Dispute Act of 1947. So, the Act has made changes in which of the following, or what are the features of the particular Act? If it is asked about the Essential Defense Services Act, it will also make changes in the Industrial Disputes Act of 1947, and the Essential Defense Service will be included in Public Utility Services, another very important change. Moving on, now let's talk about pardoning powers of the President, which has been in the news, and the Governor as well, and Section 433A CrPC. Okay, first point is, recently Supreme Court has held that the Governor can pardon prisoners even before they have served a minimum 14 years of prison sentence, threshold to be remembered, very important thing that the Supreme Court has said. Even if a prisoner has served 14 years of imprisonment, Governor can pardon the person. Governor's power to pardon overrides Section 433A of the CrPC. This has been said by the Supreme Court itself. Very important for prelims, remember that. 433A, it mandates that a prisoner's sentence can be remitted only after 14 years of jail. Okay, this has been given in CrPC. Something that has been given in CrPC is of significance from the perspective of exam if it is in the news. So, remember this article 433A. The Constitution confers pardoning power on the President under Article 72, and that is coterminous or co-in existence with Governor's pardoning power in Article 161. So, 72 and 161 are with respect to pardoning powers. President or Governor can pardon, reprieve, respite, remit, suspend or commute the sentence. Please have a look from Lakshmikant itself about pardon, reprieve, respite, commit and suspend and commute the sentence. Okay, this could be a very tricky question. You have to match the following, and pardon means what, reprieve means what. This could be in your match the following, so remember that. Okay, they have to act on the advice of the Council of Ministers. They cannot act independently. They have to act on the advice of the Council of Ministers over here as well. The President can pardon sentences which is inflicted by military courts, while the Governor cannot. This is the basic difference. Okay, military sentences are under the ambit of the President, but not of the Governor. Now, President is the only authority to pardon death sentence. Death sentence can only be pardoned by the President, and the Governor can only suspend, remit, commute a death sentence. Government's pardoning powers are limited to the cases of offences against a state law, while not so for the President. Okay, so these are the various topics that we covered. We shall come again with our next episode. Thank you so much for watching and stay engaged.